appeal is a matter of Floreat Investment Management Limited and Churchill and others.
My Lords, I appear with Mr. John Eldridge for the appellant, and my learned friend Mr. Nigel Jones, King's Counsel, and Mr. Oliver Hyams appear for the respondent. Yes, this is an appeal against the decision of Mr. Justice Robin Knowles, CBE, dated the 18th of February 2022. Judgment was given following an 11-day trial in June and July 2021. The judge dismissed significant parts of the respondent's claim, but he found for the respondent in relation to a sum of just under US 1.1 million, referred to in these proceedings as the diverted sum. Our appeal, in a nutshell, is this. First, the judge erred in law in making findings of dishonesty against Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh, the individual defendants, as they have been called. We say that he did not properly consider their subjective beliefs. First of all, as to the authority of Mr. Mutaz Otaibi, who is referred to as Mutaz to distinguish him from his brother Hussam. He didn't consider their subjective beliefs as to Mutaz's authority to act for the fund in the impugned transaction. And we say that he did not properly consider their subjective beliefs as to whether the diverted sum, if paid to the fund, would thereafter have been paid to the fund manager, Floreat Investment Management Limited, as a management fee. And we say that this led the judge into error in considering the objective part of the test for dishonesty, and also led him to consider wrongly that their consciences were affected for the purposes of the knowing receipt tort. Secondly, we say that the judge was wrong to hold that the...
Can I just interrupt you for a minute? I was warned before we came in that there was this noise and that it would be likely to drive me nuts, and it already has. If this is a live stream point, can we simply turn it off?
I don't know what it is. I have asked Ross to come and have a look at Alan.
All right.
And they don't know if it's a live stream or not.
All right. Well, we'll persevere for a bit, but if it
I
is
can contact them again.
Could you? If it is to do with live stream, we'll simply turn live stream off. Okay. Yes. Sorry about that.
Thank you. Secondly, we say the judge was wrong to hold that the individual defendants, that's Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh, had owed and breached fiduciary duties that they owed to the fund. We say that the judge, when one looks at the judgment, clearly reached a reasoned conclusion that the individual defendants did not owe fiduciary duties, but then proceeded to hold without reasoning that the individual defendants had breached those duties that he had held did not exist. We say the judge's own reasoning, and indeed the structure of the fund setup, shows this conclusion to be an error. Thirdly, we say that the judge wrongly constructed the investment management agreement in holding that FIML, Floreat Investment Management Limited, owed fiduciary duties to the fund. As we will see, those duties were excluded by contract and replaced with much more limited contractual obligations. And then finally, we say once those above errors are identified and corrected, the proprietary claim and the claim with unlawful means conspiracy essentially fall away, although I will of course address you on those more fully later. This appeal has been listed for 3 days, although I would hope that it will not in fact take so long.
Yes, I was trying to remember whether that was my estimate or yours, but it seemed to me, very much as a provisional view, that really the key issue is dishonesty. If the individual defendants were dishonest in all of this, then it would be rather surprising if they're not liable by one means or another to pay the money back. On the other hand, if they were perfectly honest in what they did, then much of the judge's reasoning falls away. I don't know. Anyway, we'll see how we go. But I think we would all encourage you to deal with it in less than 3 days if you can, particularly as in commercial terms there's remarkably little money involved in this case. I dare say there's a vast amount of costs by now, but the claim, I know it's a lot of money to ordinary people, but in commercial terms it's pretty modest.
Yes, my lord. I think it was my former solicitors had an estimate of 3 days, and that may have been at a time when one of the appellants was separately represented, which may have contributed to that.
Right. And that's no longer the case.
It's no longer the case. So just moving on to deal with a few practical matters. First of all, I hope that you all have either electronic or hard copy bundles. There should be a core bundle in 2 volumes, a supplementary bundle in 2 volumes, and a small unagreed documents bundle. And there should also be 2 volumes of joint authorities.
Yes, thank you.
In terms of the supplementary bundle, there were a few updates made about a week ago, I understand. I should confess to the court that this means that we have gone above the page limit that was ordered, because on reviewing the bundle, we noted that one document was simply missing, and in another case, the wrong document was in place. So we've put in the correct documents that were in the agreed index, but strictly we have now slightly gone over the page number that was strictly permitted.
Right. That's very candid of you, because I hadn't spotted that.
As we have just, as your Lordship has just noticed, all the appellants now have common representation. Mr. Nuseibeh originally filed a separate set of grounds in skeleton argument, which are in the core bundle, but the grounds taken and indeed the skeleton almost exactly mirrored and endorsed those put forward by the first, second, fourth, and fifth appellants. There are also. I'm sorry.
Just to inform that IT have been informed because it's an IT issue. It's not to do with live streaming as far as we're concerned.
Okay.
And even if we turn live streaming off here, it's probably
Still
continue because it was running before we turned this on anyway.
Okay, well, thank you very much
So
for
IT will,
finding out.
when they come, they've been told to come in and switch it off straight away if they come.
Very good. All right. Thank you very much for investigating that for us.
My Lords, moving back to preliminary matters, there are strictly 2 applications also before the court relating to, firstly, to the fresh evidence that the appellants seek to put in, and secondly, relating to the unagreed documents bundle, which comprises about 63 pages. By your Lordship's order, it was said that the court would read the new evidence de bene esse. I'm in your hands, obviously, as to how we should proceed with this. I'm happy to set out very briefly why we say it should be admitted. Essentially, if your Lordship...
It's opposed, is it? Yes. All right.
It is opposed.
It is opposed, but I'm quite happy if your Lordship wants to, on a practical basis, adjourn decision about it until you've heard everything.
Yes.
I don't know if that makes more confusion than it seems to solve, but it doesn't seem to me a good use of our time to start with that. And as you've read all the material,
yes. Well, I'm inclined to agree with that. So
I'm very, very, very happy for the just.
Yes. All right. Well, why don't you proceed in that way, and in the course of your submissions, you can.
Thank you. I will refer to it. It won't take long to refer to, as you've seen. It's a narrow point related to our general ground and the disruption of the preparation of the judgment. It's all it goes to. The second application relates to the unagreed documents bundle. This comprises, first of all, the witness statement, the trial witness statement of Mr. David Whitworth, who is one of the directors of the fund and a director of various other entities. We refer in particular to 2 short passages of that regarding the circumstances in which, as a director of IR Relations Limited, which is the 4th appellant and the offshore entity to which the diverted sum was paid, the circumstances in which, as the director of that entity, he was entitled to see and did in fact see the bank statements of that company for the relevant period, for 2017. The other parts in the unagreed documents bundle are extracts from the cross-examination of the 3 individual defendants. These go to points made at paragraphs 49A and 50B of skeleton argument filed. And the reason why they're included relates squarely to the question of dishonesty, which, as your Lordship has said, is absolutely central to this appeal. We say that at trial, each of the individual appellants gave written and oral evidence to the effect that he believed that the termination fee, if paid to the fund, would definitely be paid out to FIML as excess. And we said that this belief was not squarely addressed by the judge, who didn't engage in a reasoned analysis of the relevant evidence. And we have identified, and I will take your Lordships to in due course, the relevant parts of the transcript, which we say just set out the key parts of the defendant's evidence on that point. Those extracts also go to the second key issue I highlighted in opening, which is the fact that we say the trial judge did not make a finding as to whether each of the individual appellants subjectively believed that Mutaz, Mr. Mutaz Otabi, had authority to act for the fund in relation to the treatment of the termination fee. And again, the unagreed documents bundle includes relevant passages of trial transcripts. The supplementary bundle itself already includes one or two extracts from cross-examination of Mr. Diallo, for example, which the respondent wished to go in, as I understand it, and we were happy to agree. So there seems to be no objection in principle to extracts from cross-examination going in when relevant. And it's slightly difficult from this side to understand why the respondent is resisting this material going before the court. In the normal way, the bundles were filed 6 weeks before this hearing. There was communication between the parties about the inclusion of these extracts for some time before that. If there was some objection that these were partial, it would have been possible for them to include longer extracts. And indeed, my solicitor's original proposal was to include longer and fuller extracts in order to give the court a broader picture of the cross-examination. But as the respondent resisted and said that these were far too long, cut it down to what we considered to be the essential pages.
Yes. I mean, is this an appeal on fact in the sense that you're saying the judge got the facts wrong, or are you just saying he didn't make findings? Because it seemed to me that there are paragraphs in the judgment where the judge does make a finding that the individual defendants knew that they weren't supposed to take the money.
Well, we say that we'll obviously come and look at this in detail, but we say that when the judge makes that finding, he makes the finding in terms which don't fairly represent what happened. So, for example, he makes a finding that the individual defendants knew that Mutaz was not authorised to deal with the funds entirely as he wished, as if he was simply paying it to a completely unconnected third party. And we say that, in fact, of course, what he was doing, what Mutaz was doing, was treating the funds as if paid to FIML by the fund, which we say would have happened. And it's very different to engage in what we've called a contractual shortcut, rather than simply paying the money away to a wholly unconnected third party. So that's why we say the judge, when he makes those particular findings, we say that's not really the relevant or apposite finding for the test of dishonesty which he had to make. It is true that we then go on to say, well, if one looks at the evidence of the individual defendants, there is a considerable amount of evidence included in this unagreed bundle, which demonstrates fairly clearly what they did think. And if the judge was going to disbelieve that evidence in the way that they put it, then we say he should have given proper reasons for it and fully engaged with it. And we say he didn't do that. So the purpose of these extracts is partly to show the extent to which this was canvassed at trial. This wasn't simply a passing comment by one of the defendants at trial, which the judge might reasonably overlook or think wasn't significant. This is a very significant issue, and that's why, in my submission, these are matters that the court should...
Right. Well, I suggest that you take us to those passages if you need to, and then if Mr. Jones wants to object to us looking at them or having any regard, he can deal with that when he comes to make his submission.
Yes, so thank you, my lord. Then at the relevant point, I will take you to show your lordship the relevant parts of the cross-examination. My lord, so then moving on to what I hope will be a relatively brief summary of the key facts of this case. I'm, of course, aware that your lordships have done a certain amount of pre-reading, but I think it may be helpful to identify some of the key points which may not necessarily emerge from the judgment or from the skeletons.
Yes.
So the appeal concerns the destination of parts of a contractual termination fee payable by the Reading Football Club on its early repayment of a loan of some 22 million, provided to it by Global Fixed Income Fund 1 Limited, referred to as the fund. And this termination fee was 2.2 million, the disputed part, the diverted sum, is 1.1 million less than bank charges. The claim is brought by FIML, who is of course the manager, but as assignee of the fund. The early repayment of the loan to Reading Football Club was negotiated by FCM London, the investment advisor, acting by its employees, the first to third appellants, the individual defendants. The other defendants are IR Relations Limited, which is generally referred to as IRL. And this was previously called Floreat Investor Relations, and so you may have seen some reference to FIR in the witness statement bundles. And that, as I mentioned earlier, that was the offshore Cayman entity to which the diverted sum was originally paid and is owned by the three individual defendants. The claim against IR Relations was brought in relation to knowing receipt and the proprietary claim. The fifth appellant, Mrs. Fatoumata Diallo, is the wife of Mr. Diallo. The only claim brought against her is the proprietary claim, as 1/3 of the partial termination fee and dispute was ultimately paid into a joint bank account she held with Mr. Diallo.
The judge didn't make, did he, any findings about her state of knowledge?
No, it wasn't. It was purely a proprietary claim that was brought against her.
Yes?
At this point, it may be helpful to look at the diagram which was attached to the defendant's skeleton argument at trial, which is at C439.
Sorry, can we have that reference again? Sorry.
Sorry, I'm sorry, S439. I apologize.
I'm so sorry, I must be looking at the wrong page. Supplementary bundle?
Supplementary bundle.
Second
Supplementary bundle.
Yep.
You're working off a hard copy.
349?
439.
Oh, 439. Thank you.
This was the diagram appended to the defendant's skeleton at trial. And it may help to, if your lordships haven't seen it already, it may help to conceptualise the structure of this fund. So at the top in the middle is the fund itself. And it had a subscription agreement with its investors, as you'll see on the right-hand side. And the investors held the non-voting shares in the fund. The voting shares in the fund were held by FIML. That's not marked on the diagram, but we can see that from the offering memorandum. Reference for your lordships is S84, but we don't need to go there now. The directors of the fund were Mutaz, David Whitworth, who was an offshore director, and Christopher LeBeau, who was a director provided by Maples, fiduciary in Cayman, who were the administrator of the fund. If we move down from the fund had an investment management agreement with FIML. It appointed FIML as its investment manager. FIML also owned the voting shares in the fund. And Mutaz was, from July 2016 until April 2018, so at the relevant time, he was a director of FIML, and the judge held that he was the sole executive director of FIML, although there were various others as well. The judge held that at paragraph 27 of his judgment and noted there were other directors at paragraph 30. Below FIML is Floreat Capital Management. This was the investment advisor. this was also in the judgment referred to as FCM London because it was incorporated in England and Wales, whereas there's another FCM which was incorporated in Cayman, which we'll see on the left-hand side. So FCM London, the directors of that were Oumar Diallo and Mutaz, so two directors, and it was held 50% by the individual defendants, so that is Mr. Diallo, Mr. Nuseibeh, and Mr. Churchill, and 50% by Floreat Holding Limited. Floreat Holding Limited was ultimately owned by Mutaz, his brother Hussam, and to a small extent by Mr. James Wilcox. The individual defendants had employment contracts with FCM London. If we then move back up the chain, you'll see that there was also a placement agreement with Floreat Merchant Bank. And that was, as it says, owned by FHL. So again, that's ultimately owned by Mutaz, Hussam, and Mr. Wilcox. And the directors of Floreat Merchant Bank were Mutaz and Mr. Wilcox. The sole shareholder of FIML was Mutaz. And we find that at paragraph 27 of the judgment. If we move across the page a little, we see Reading Football Club, the top left. And this was the Reading Football Club had taken out effectively a loan from the fund, which this litigation relates to. And below Reading Football Club, you will see towards the right, there's FAL, Floreat Advisors Limited, which is a Jersey entity. And this was an entity to which fees had previously been paid. So, for example, the introduction fee in relation to the RFC loan was paid to FAL Jersey. And that in turn was held by the individual defendants, 50%, and Mutaz, 50%, although the defendants contended that this was held on trust by him, also for his brother Hussam and Mr. Wilcox. To the left of and underneath Reading Football Club, you will see, first of all, IRL, a company we've mentioned a couple of times, which is the company in Cayman owned by the individual defendants. The sole director of IRL was Mr. Whitworth. So Mr. Whitworth, you will recall, is one of the three directors of the fund. He's also a director, the sole director of IRL, which received half the termination fee. The other half of the termination fee was paid to FCM Cayman, which was a Cayman company owned by Mutaz, again we say on trust for his brother and Mr. Wilcox. And Mr. Whitworth was the sole director of FCM Cayman as well. So Mr. Whitworth was the director of both the entities to which the fund was paid. So not shown on this, I should perhaps say in fairness that there is a rival diagram, which is at S388, which was produced at trial by the claimants. There were some issues, should we say, there were some things shown on that diagram that the defendants did not agree with, which is why they, even though skeletons were filed consecutively, they didn't simply agree that diagram, but produced their own. So that is the overall structure, and you can see from this that it's not marked on this particular diagram, but as I've explained, so Mutaz was one of three directors of the fund, one of a number of directors of FIML, but the sole executive director. He was a director of FCM. FIML owned all the voting shares in the fund, and Mutaz owned all the shares in FIML. For good measure, Mutaz was also a director of Floreat Merchant Bank on the right-hand side. Having had a look at the entities and the structure, it would be helpful now, I think, even though we will come back to them at various points to have an overview of the key agreements which govern these various relationships. And these are in bundle S, the first S bundle. And I'd like to start, please, by looking at the tab 4, which is the Fund's Confidential Information Offering Memorandum. Page 58. Are your lordships all working off the hard copy?
It looks as if we are, yes.
So this is the offering memorandum. It's obviously lengthy, and I certainly don't propose to invite your lordships to read the whole thing. But I will take you to some of the key points in it, which I will refer, and no doubt my learned friend may take you to some more. But could I ask you, please, first just to look at page 63 of the bundle, which lists the directors' officers and advisors. This is the fund's offering memorandum, and you will see it lists the directors of the fund at the top. It lists the investment manager, Floreat Investment Management Limited. Underneath that, the investment advisor, the administrator, the auditors, the banker, the legal advisors to the company. There are 2 points I would draw your attention to here in terms of the dog that didn't bark. The first is that there's no mention of the individual defendants by name in this setting out the structure of the fund, only the investment advisor, FCM London. And there's no mention of the placement agreement with Floreat Merchant Banking. If I can invite you then to turn to page 66. You will see the fourth defined term is term, which states that the intended term is 5 years from the closing date. I don't need to take you there. We find it at S113, where the closing date is said to be the 31st of December 2015, unless varied by the board. If you look 3 terms down to fees and expenses, you will see that it says all the fund's preliminary and organisational expenses, including fees in connection with the incorporation and registration of the fund, shall be borne by the manager. The ongoing operating costs and expenses payable by the fund, other than the payments to the investment manager, will, under the investment management agreement, be borne by the investment manager out of its own resources. These costs and expenses include, but not limited to, those covering the fees of the administrator, directors, auditor, banker, and so on. And this connects, this rather unusual arrangement where the manager pays all the fees, is connected to the rather unusual arrangement in relation to the management fee, which we find on the next page, on page 67. Where it says no pro rata management fee is payable. However, the manager will, in lieu of any fee, be entitled to retain 1, in respect to the first 9 months, any excess in the net income over an annualised 5% on the fund subscribed, and in respect of each subsequent quarter, any excess in the fund's net income over the amounts required to fund the preference dividend, including any accrued but unpaid, in each case after taking into account any impairment in the holding value of any loan or investment, or any realised loss or shortfall following repayment or disposal, and then also on a winding up. Below that, it provides, if in respect of any period there is a shortfall, taking into account the funds held in the cash reserves, and the target level of preference dividend cannot be paid, so that's a shortfall in the fund's assets. So if the target level of preference dividend cannot be paid, the shortfall will be carried forward and offset against any excess for the following period, and thus taken into account in determining the level of remuneration payable to the manager in respect of the following period. So this is the slightly unusual nature of this fund, which is that the manager, or the investors rather, get a fixed 5% return, but their capital is also at risk. And everything above the 5% return is for the benefit of the manager. And the manager also has to bear all the costs of the fund. And this, the individual defendants, there is some evidence to the effect that they considered that this wasn't really a commercial fund in the normal way, because there was obviously an incentive on the manager to engage in very risky investments with a high return, because the manager, if successful, the manager would get all the upside above 5%. But obviously, if there was a downside, then it would be the investors who would bear the brunt. The manager would not bear the costs, save only to the extent that he didn't receive a fee.
You say it wasn't an ordinary commercial fund. Did the judge make any finding to that effect?
No, he didn't. If we look above this point of management fee, I would draw your attention to where it says placement agent's fee. No introduction of placement fees will be payable by the fund. Any placement agent's fees will be met by the investment manager pursuant to the placement agency agreement. This is the only mention in the main body of this memorandum of the placement agent or the placement agent's fee. As we saw, it didn't appear on the first page. It appears in two other places, just for completeness, so I needn't take you there. It's defined in the glossary at S114, and there's a passing mention of a placement fee in relation to investors in Switzerland at S122. Fundamentally, this seems to have been, the placement agent seems to have been, to some extent, an afterthought. If you could please then turn to page 69 of the bundle. So here, this is a section which is in fact appears in the judgment. The first paragraph at paragraph 15 of the judgment, the second one at paragraph 17 of the judgment. It just summarises what we've seen, which is that the fund pays the costs and the fund receives a management fee essentially equivalent to everything above the 5% paid to the shareholders. At the bottom of this page, in this paragraph, the loans and investments will typically have a repayment or redemption date during the target life of the fund. I'd invite you to, if you look about 5 or 6 lines up, this is a point that my learned friend would no doubt wish to take you to, and certainly was an issue at trial. It says, if break costs, a prepayment fee, or premium over principal or equivalent, is or are payable on early repayment or disposal of a loan or investment, these costs, break fee or premium, will be added to the fund's cash reserves to meet any shortfalls in income received or principal repaid. Quite a lot of this offering memorandum is repetitive, so one finds those words. It repeats the principle of the only the 5% being paid to shareholders and the rest being paid to the manager in several places. In fact, those words about break costs also repeat, for example, on page 72. If I could invite you then to turn to page 75. Fund management structure and organisation. Just note the third paragraph down says the term of the fund is 5 years, but may be extended by 2 additional 1-year periods at the discretion of the directors. And so the closing date, as defined, was 31st of December 2015. Gives you an idea of the intended length of the fund. The directors of the fund, Mr. Mutaz Otaibi is top of the list, and in the description, as you will see in the second paragraph, 3 lines down, it says of him, he currently serves as a managing partner and the CEO of the Floreat group. It then mentions David Whitworth, who was one of the offshore directors. And over the page, it mentions Christopher LeBeau. If one looks at the second paragraph of that page, you can see that it says the services of Christopher Lebeau are being provided by Maples Fiduciary, who is the administrator of the fund. Maples Fiduciary has entered into a director's services agreement with the fund, which sets out the terms on which it will provide the services of Christopher Lebeau. If you then skip a paragraph and look at the next one, the directors provided by Maples Fiduciary are non-executive directors of the fund and are not required to devote their full-time attention to the business of the fund. About 2 lines down, it continues, neither Maples Fiduciary nor any of the directors supplied by Maples Fiduciary are responsible for 1, the commercial structuring of the fund or its investment strategy, 2, the purchase or sale of any investment on behalf of the fund, which is the responsibility of the investment manager, following receipt of advice from the investment advisor, 3, the valuation of the assets of the fund, or 4, any loss or damage caused by the acts or omissions of the investment manager, and so on. You will see at the end of that paragraph that they are exempt from such loss unless occasioned by actual fraud, willful default, or gross negligence of the directors. And the BBC, it recites in the paragraph below that the articles make a similar provision that the directors shall not be liable for loss or damage unless arising from actual fraud, willful default, or gross negligence. We turn to page 77, and this then sets out information about the manager, Floreat Investment Management Limited, Fimmel. In the offering memorandum, towards the bottom of this page, you can see that it lists Hussam Utaibi as one of the 2 directors. He was a director up until the 29th of July 2016, when he was replaced by Mutaz, and that's in the judgment of paragraph 27. And that's the point at which the judge also finds that at that point Mutaz was the sole executive director of FINMA. If we turn, please, to page 79.
Is that description at page 77? There's a potted description of the investment management agreement. Is that a fair summary of it?
Which part are you looking at here?
The fund has entered into the investment management agreement.
Yes, it's a very broad summary. We will look at the investment management agreement in a moment. So we're then turning to, please, to page 79. Again, there's a reiteration of the management fee and the point that if there's in the following paragraph, if there's a shortfall, the shortfall be carried forward and offset against the management fee for the next period. At the bottom of this page, the offering memorandum talks about the investment advisor, Floreat Capital Markets Limited, FCM London. It says FCM London has been appointed by the investment advisor of the fund with effect from the launch of the fund. The investment advisor is responsible for advising the manager about potential acquisition and realisation of loans and investments. The next paragraph says the investment advisor's team consists of experienced professionals with strong track records in investment, covering origination, execution, legal and operations. The members of the investment advisor team includes, and there then follows, it names specifically Ben, Churchill, Oumar Diallo and Zaki Mohammed Nuseibeh. I would of course point out that my learned friend says the fact that they're specifically named in the investment memorandum is a reason to suggest that the fund relied on them in terms of their own fiduciary duties direct to the fund. In that context, while we're here, I would simply point out that the relevant wording says that the team includes the following. It certainly doesn't preclude any others from participating. Each of the individual defendants here is described as a partner and shareholder of Floreat Capital Markets. This language of partner is, of course, used loosely, but they were not partners in any real sense, as the judge found. On page 81, about 5 paragraphs down, is the heading Investment Advisory Fees. And it says, the fees of the investment advisor under the investment advisory agreement shall be met by the manager out of the management fee and will generally be agreed on a loan-by-loan or investment-by-investment basis. So it's a fee that expressly comes out of FINO's management fee to be agreed loan-by-loan.
Does the judge make any findings about what was agreed so far as excuse me, FCM London's fee is concerned on this particular transaction with Reading Football Club?
Well, the judge makes findings that it was agreed that between Mutaz and the individual defendants that half the termination fee, so the diverted sum, should be paid to
Yes, well, he certainly makes that.
IRL, and he also previously makes the point that it was not uncommon for, and had previously happened, that fees which were notionally earned by FCM London were paid offshore. So at one point they were paid to Floreat Advisors Limited, a company in Jersey.
But there's no finding that in relation to the loan to Reading Football Club, the fee for FCM London would be such and such. Or is that not how it worked?
I don't think he puts it in quite those terms, so I may have to come back to you and just see exactly how he puts it. And because certainly it was discussed in terms of the contractual chain that this was that FCM London was, he says, entitled to a fee. And certainly there's been no claim by FCM London subsequently saying, no, I'm entitled to a fee from FIML, because
well, he says they get their salaries, and he says they get whatever dividends would be payable by FCM London out of the profits that they earn. But he doesn't, I think, identify what those profits are going to be. Presumably, they're fees, but I wasn't sure I could see what the fees were, which they were supposed to earn from this transaction.
My lord, as I said, I would have to just double check exactly how he puts it, because it seems to have been assumed that this diverted sum represented FCM London's entitlement to a fee from this transaction. That's certainly the basis on which the evidence showed it was negotiated. It was negotiated in relation to this transaction as part of the individual defendant's share. At trial, of course, the individual defendant said there was an overarching joint venture agreement, which meant that they were entitled to 50% of the profit from the fund generally. Now, the judge rejected that suggestion, rejected that allegation, but of course noted that they were entitled to 50% of the profits generated by FCM London. And so, although there was no formal agreement outside the contractual structure, as the judge found, that they were entitled to 50%, nonetheless, in the normal way, they would achieve effectively 50% of the dividends were paid by FCM London in the usual way.
Well, if you could come back on that as necessary once you've identified exactly what the judge says, that might be helpful.
FCM London presumably wouldn't be entitled to anything as it were going into the transaction. I mean, they are the investment advisor.
Yes.
So they don't get a fee going in.
That's right.
Coming out, if there's an early termination, the basis for a negotiation of a fee would be what? That they're compensated for the lack of the ability to earn some other form of investment management fee?
We'll have a look at the investment advisory agreement, and one of the points I would make is that the investment, although it seems to have been argued at trial that there was a contractual entitlement by FCM London to a fee from FIML, if one looks at the investment advisory agreement, it's actually very unclear as to whether what amount of fee was ever going to be due and paid. It simply says, we'll come to it, to be negotiated effectively on a case-by-case basis, both as to amount and as to how it should be dealt with. So it seems that that's perhaps why, dealing with the earlier point, perhaps why I don't think there's an express finding saying this amount was expressly FCM London's fee, although it seems to have been assumed, because as soon as the money went into FIML, there had to be a negotiation between FIML and FCM London as the amount of any fee. Now, this is getting ahead of myself a little bit here, but this is, as we'll see, the structure of the fee due to FCM London and also to Floreat Merchant Bank. In both those cases, there was no automatic entitlement to a clear fee as there was in the case of the investment manager, as we've just seen. It's left very much up for negotiation in every case. I'm afraid we're still in the offering memorandum. There are a couple more pages I would like to show you. One is at page 89. Where it says risks associated with the manager, the investment advisor, and other service providers. That's the heading halfway down. It says the fund is dependent on the expertise of the manager, the investment advisor, and their key personnel to evaluate investment opportunities and to implement the fund's investment objective and investment policy. In accordance with the investment management agreement, the fund has engaged the manager to provide investment management services. The fund does not have employees, and its directors are or will be appointed as non-executives. All of the fund's investment decisions are based on investment recommendations made by the investment advisor. The fund is dependent on the manager and the investment advisor for sourcing loans and investments. The manager's and the investment advisor's ability to do so will be in part dependent on the industry relationships of the key personnel of the manager and the investment advisor. The fund cannot be sure that the manager's and the investment advisor's relationships will be maintained, whether as a result of changes in the key personnel of the manager or investment advisor or otherwise. And then in the final paragraph of this page, the final 4 lines. In the event of a departure of a key partner, director, or employee of the manager or the investment advisor, there is no guarantee that the manager or the investment advisor will be able to recruit a suitable replacement, or that any delay in doing so would not adversely affect the performance of the fund. I draw your attention to that to make the point that the offering memorandum itself envisages that the personnel of both FIML and FCM London might change. So although the individual directors are named as part of the team, FCM London's team, that team includes them, there's a recognition here that they're not bound into FCM London. It's a risk that they might leave. And the very final point I'd like to make on this document is over the page at page 90. The penultimate paragraph. It just notes that the manager and or any affiliates may be involved in other financial investment and professional activities that may on occasion give rise to conflicts of interest with the fund. Potential for conflict of interest is flagged up there. So that is the offering memorandum attached to the investors' subscription agreements, which the judge found was part of the agreements with the investors. And that sets out the structure, so I hope it'll be a little quicker going through the remaining documents. But if I could ask you please to turn to the same bundle, page 5, which is the investment management agreement. This is between the fund and FIML, who is defined as the manager in this document. And I'd ask you first, please, to turn to clause 3.1, which is at page 9. Where it says, during the continuation of the appointment hereunder, subject to clauses 3.9, 3.10, and 3.14, the manager shall take all day-to-day decisions and otherwise act as the manager deems appropriate in relation to the management of the portfolio for the account of the fund, without prior reference to the fund. And then 3.2 says the manager shall have full power and authority subject to the terms of this agreement and memorandum in respect to the fund in all these various respects. If you turn the page, clause 3.4 puts into this agreement the obligation of the manager to pay the fund's organisational and operating expenses. Paragraph 3.7 says the manager shall not hold itself out either expressly or ostensibly as acting as the agent of the fund, except in accordance with the provisions of this agreement or any other agreement. 3.8, the fund hereby irrevocably appoints the manager with full power of substitution to be its attorney during the term of this agreement, to sign or execute on its behalf all documents which the manager acting reasonably deems necessary or desirable in connection with its appointment. And 3.9, all activities engaged in under the provisions of this agreement shall at all times be subject to the overall policy, supervision, review and control of the fund, which may by proper instructions give to the manager general or specific directions related to any matter which is the subject of this agreement. Proper instructions is a defined term at page 8. About 3/4 of the way down. It says proper instructions means instructions given in accordance with clause 12 in respect of any of the matters referred to herein by any director. Paragraph 3.16 on page 11. The manager, that is FIML, shall have full power and authority to appoint as investment advisor and or to delegate the performance of its investment management services under this agreement to any associate, provided that the manager shall notify the fund in writing as soon as reasonably practicable of any such delegation or appointment. So this means that where FIML appoints an associate, the fund has no say at all, it's simply notified. And in this case, the judge found that FCM London was an associate of FIML, and that's at paragraph 337 of the judgment. Any delegation or appointment otherwise than through an associate shall be subject to approval by the fund, and such approval not to be unreasonably withheld or delayed. So in terms of selecting the investment advisor, the fund had no say, in fact, when an associate was selected. But even in principle, where FIML wished to appoint someone who wasn't an associate, the fund's role would be limited to approving acting reasonably. It couldn't choose it for itself. Carrying on with this clause, subject as provided in clause 10, or as may be agreed with the fund from time to time, any delegation or appointment pursuant to this clause 3.16 shall be entirely without prejudice to the manager's liabilities, obligations and responsibilities hereunder, and the manager shall be responsible for the acts and omissions of its delegates as if they were its own. So here we see that there is a contractual burden placed on the fund to be contractually responsible for the acts of its delegates, acts and omissions of its delegates. I'm sorry.
You said on the fund, you meant...
I'm sorry.
Yes.
I meant
Just check.
Thank you.
That's all right.
Turning the page, paragraph 4 is remuneration. This is the agreement between FIML and the fund, of course, and this sets out in detail the manager's entitlement. Entitled to retain, very much as we've seen before, in respect to the first 9 months, any excess in the net income over an annualised 5%. And so on. And then quarterly, it's entitled to the same thing, each quarter ending on 31st of March, 30th of June, 30 September, 31 December in each year. And paragraph 4.3, it provides, except as required by any statute, law, or regulation to which it is subject or is otherwise agreed in writing, in this agreement or elsewhere, the manager and each associate shall be entitled to retain any fees or expenses paid or payable to any of them by any third party. The manager shall provide the fund with requisite information about such fees and expenses on a case-by-case basis, including where so requested the amount of such fees and expenses. So this is some of the provisions which show that there can be conflict of interest between FIML and the fund. If you turn the page to clause 5.1, says the fund acknowledges and agrees that the manager and its associates, so this includes FCM London, may, without prior reference to the fund, act in circumstances in which the manager or one of its associates has a material interest or a relationship of any description with another party, which may involve an actual or potential conflict with the manager's duty to the fund. So this is very wide wording in terms of provide an exemption to what one might call the no conflict rule of fiduciary duties. However, if the manager acts in circumstances where it has a material interest or conflict of interest, the manager will take all reasonable steps to ensure the fund is treated fairly. So the no conflict rule is suspended, and it's replaced by this contractual obligation on FIML to treat the fund fairly, to ensure the fund is treated fairly. In this regard, the manager has established, implemented, and maintains a written conflict of interest policy, a summary of which has been provided to the fund. Neither the manager nor any of its associates, including FCM London, shall be liable to account to the fund for any profit, commission, or remuneration made or received in such circumstances, and nor will the manager's fees be abated as a result. So that's what one might call the second limb of the standard fiduciary duties, the no profit rule. That also seems to have been abated. So clause 5.1 is drafted in very wide terms and replaces the no conflict rule and the no profit rule with a contractual obligation to ensure the fund is treated fairly.
Why do you say it replaces it with a contractual obligation? Isn't this a contractual modification of a fiduciary duty?
It is, but I suppose the reason why I say replaces is because it effectively exempts from fiduciary duties the two core features.
Doesn't it modify to some extent the core fiduciary duties of a fiduciary? But it doesn't say, for example, that there are no fiduciary duties.
No, it doesn't. It doesn't here. But I say the way in which it's set out is that it attacks, as I would say, the very core and essence of what it means to be a fiduciary. Because it says that they're entitled to have conflicts of interest. And where they have conflicts of interest, they don't have to account for any profit, nor indeed can their fees be abated. And what we find instead is that where there is a material conflict of interest, the manager will take all reasonable steps to ensure the fund is treated fairly. So,
do you say the consequence is that FIML is no longer a fiduciary as a consequence of this?
Well, I would say this goes a very long way towards that. It's very hard.
Well, it's like saying you're sort of half pregnant. I mean, is it or isn't it, or does it not owe fiduciary duties as a consequence of this clause?
Well, certainly as a consequence of this clause and clause 13 in combination, I would say it doesn't owe fiduciary duties. I think this clause in itself is probably enough too. Certainly, given the scope of this clause, if in a finding that any fiduciary duties were owed, it would be important to identify exactly what they were, to see whether or not they fell within what appears to me to be very broad wording in this clause. Now, it is, of course, the case that fiduciary duties aren't always the same and can be different in particular circumstances. But, as I will come on to, you would expect the judge, in finding that FIML owed fiduciary duties, given these various exclusion clauses, if you were to find that any were owed at all, it would be quite important to say exactly what they are.
Well, it would be very easy to say in an agreement like this that FIML is not a fiduciary and does not owe any form of fiduciary obligation to the fund.
Well, I would say that it does say that at clause 13, although the wording of it is not very... Moving on to clause 5.5 of this investment management agreement, it says the manager will normally act as the agent of the fund, who will therefore be bound by its actions under this agreement. None of the services to be provided under this agreement, nor any other matter, will give rise to any fiduciary or equitable duties which would prevent or hinder the manager or any associate in transactions with or for the fund, including acting as both principal or agent, dealing with other associates and other customers, and generally affecting transactions as provided above, to which the fund consents accordingly. Now, again, although the wording could be clearer, this is another fairly broad waiver of fiduciary duties arising in connection with any transaction with or for the fund.
Well, surely if they'd wanted to exclude fiduciary duties, they would have put a full stop after the word duties and not bothered with the rest of the clause.
Well, one might say this agreement could be better phrased in a number of respects, but I'd say that this is clause 5.1 and clause 5.5, and they're seeking to cover all bases by perhaps using more language than they strictly need to.
You see, the reason I asked you, amongst other things, about whether, and sorry, I know you may come on to deal with this more generally, but the reason I asked you, amongst other things, about the description in the investment memorandum of the investment management agreement was that it would leave investors with the impression, wouldn't it, that the responsibility for management of their fund rested with the investment manager. And the words, so I'm struggling to find it was 77, at page 77, the description talks about the manager being provided with power and responsibility for managing the assets of the fund. I mean, that is the sort of wording that you would ordinarily see used to describe somebody who was a fiduciary.
Yes, I would agree. That
where in the investment memorandum does it say to investors in the fund, oh, and by the way, the investment manager doesn't owe any fiduciary duties to the fund?
Well, I took your lordships to page 90, where it doesn't say it in terms of no fiduciary duties being owed, but it does say the manager and its affiliates may be involved in other financial investment professional activities that may on occasion give rise to conflicts of interest in the fund.
Well, but then it doesn't go on to say, and in those circumstances will be quite entitled to prefer the interests of other people rather than you. I mean, that's what you would expect if, in fact, there were no fiduciary obligations owed to the fund. You'd expect it in a pretty clear explanation to the investors in the fund, wouldn't you?
Well, the investment management agreement is, of course, aimed between the fund and its manager.
True, but I'm looking at the way this was presented to the investors in the fund, just because you started there.
Yes.
Good place to start.
Yes, no, I would agree that it simply says there can be occasion give rise to conflicts of interest. It doesn't say how those conflicts are going to be regulated. And we've seen in the investment management agreement that it isn't left as a complete free-for-all. It's still an obligation to treat the fund fairly, as we said in clause 5.1. But it's the difference between there being a freestanding fiduciary obligation, common law fiduciary obligation, and there being the matters that the fund has to do set out in the contract, the contractual obligation to treat the fund fairly, to carry out the various activities, to be responsible for its delegates, to be responsible for FCM London's act as if they were its own. Doesn't mean they have no liability, but it does mean their liability, in my submission, is contractual and not based on a fiduciary duty.
But isn't the more natural reading that there is still a residual fiduciary liability in circumstances where, for example, they do not act fairly in accordance with the contractual obligation by, for example, misappropriating trust money to which they otherwise ought to account?
Well, if they didn't act fairly, then there would presumably be a claim for breach of that contractual provision.
Well, there might be, but why not have a breach of fiduciary duty as well? Because that is the normal duty imposed on agents or others in a similar type of position.
Well, that might be normal, but in my submission, this was not a wholly normal fund. You've seen how Mutaz he was a director of the fund, but also a director of the investment manager and also a director of the investment advisor.
He seems to have had a finger in every pie.
And so when setting up a structure such as this, it's not as surprising as it might be in a purely commercial fund, which we say this wasn't, to find that actually they're very wide-ranging waivers of duty because Mutaz at the centre of it, presumably, wanted to have a free hand.
Shouldn't we perhaps approach the matter on the footing one would expect to find fiduciary duties not to be wholly excluded, but certainly could be modified? I mean, that's commonplace. For example, in a different context in private settlements. You often have all sorts of provisions relieving settlors, trustees from fiduciary duties in their full extent in certain circumstances. For example, to enable dealings with property in which they have a personal interest and all that kind of stuff. So that's a familiar type of pattern, and it seems to me at the moment that that is, on the whole, on a natural reading, what we have here. I mean, there may be argument for quite what the small print means in every particular place, but if one was, if the real intention had been a wholesale exclusion of all fiduciary duties, one might expect to see that pretty clearly spelled out. Perhaps you're going to say it is pretty clearly spelled out.
In my submission, we'll come on to clause 13,
yes.
which, as your lordships will be aware, is headed waiver of fiduciary duties, and we have an issue about the relevance of the clause heading. But I'd say that really is clearly spelled out. And the reason why I'm also looking closely at these other provisions is to show that that doesn't come out of the blue, as it were,
No.
contractual structure.
And of course, you're absolutely entitled and indeed right to say we have to construe the agreement as a whole. So we have to look at all these.
We have to look at all these provisions and see how they
interact.
How they interact, exactly. And if you say, shouldn't it be clearly stated? I would say, well, the clause headed waiver of fiduciary duties is pretty clear.
Are we able to construe the investment management agreement also by reference to the offering memorandum?
Well, the investment, I think it's not in dispute that this was set up as a particular structure in the way that the investment management agreement was very briefly summarised in the offering memorandum.
I mean, they're contemporaneous document. I mean, there are quite a few authorities, aren't there, where a structure is set up like this and a representation is then made to investors as to what the structure means. Are we entitled to construe the investment management agreement by reference to the way that it was portrayed to investors?
I'm not sure that saying a representation is made to investors when one's construing this agreement and saying what does it objectively mean, then obviously if there are representations made to investors, and that was a fact known to both parties, as it would have been
in a contemporaneous document,
then it's part of the background known to both parties, which might help to construe it objectively. But I'm not sure I was really suggesting to go quite this far, but it sounds almost as if you're saying, would they be bound by representations made to shareholders? And I wouldn't go that far.
You would obviously not like there to be any fiduciary duties owed by FIML to the fund.
Yes.
And in answering that question, we obviously look at the investment management agreement in its context. And the only point I'm putting to you is that where there is an offering memorandum to investors in the fund describing the structure of which the investment management agreement is a central part, are we entitled to look at how it was represented to investors?
Well, I'm sorry if my previous answer wasn't clear. I would say that the fact that it's represented to the investors in one way is one person's subjective understanding of what the investment management agreement means. It would seem to me if you're saying it's a representation as to what this agreement means, and in my submission, that doesn't determine what it means because the agreement has to be looked at objectively. If you were to take a slightly less strong view and say the offering memorandum is part of the background which would be known to both parties in drawing up this agreement and is part of the background that might help you to interpret this agreement, then I wouldn't dispute that. Okay. We have, if we can return, please, to still on the investment management agreement, and we're just looking at clause 5.5, and the next clause I would invite you to look at is clause 10 on page 15. And this is a limitation of liability clause. The manager will not be liable for any damage, loss, claims, proceedings, demands, liabilities, costs or expenses whatsoever suffered or incurred by the fund, save to the extent that such loss arises directly as a result of the actual fraud, gross negligence or willful default of the manager or its officers or employees, in which case the manager's liability to the fund should be limited to an amount of no more than US 5 million. It's worth just looking at the definition of gross negligence, which is on page 8. About the fourth entry down. Gross negligence in relation to a person is a standard of conduct beyond negligence, whereby that person acts with reckless disregard for the consequences of a breach of duty of care owed to another. So it imports some notion of fault. It's not merely a slightly higher standard of negligence, perhaps, if I can put it that way. So the limitation of liability relates to actual fraud, gross negligence, which is reckless disregard for the consequences of a breach of duty of care, or willful default. So again, this is part of the pattern of setting up really quite protective measures for the manager, if I can put it like that. And then clause 10.3, the fund shall fully indemnify the manager, its associates, and their respective officers. So, as we know, the judge found that FCM London was an associate of FINL, and so this would seem to apply to the individual directors. The fund shall fully indemnify the manager, its associates, and their respective officers, employees, and agents from and against any loss which such indemnified person may incur in the course of, or as a consequence of the performance of the manager's duties, except to the extent that such loss arises directly as a result of any actual fraud, gross negligence, or willful default of the indemnified person in question, or their officers and employees. Just going back a step to my Lord's question a few moments ago, and we saw in the offering memorandum that in relation to the directors, that they would only be liable in cases of actual fraud, gross negligence, or willful default. Remember that wording came in the offering memorandum too. So we then come on to page 18.
What's the relevance of clause 10.3? Because the fund hasn't sued FIML. And indeed, as FIML is the assignee of the fund, that would be an interesting piece of litigation.
The fund has not sued FIML. It's part of the, I'm drawing these matters to your attention as part of the contractual structure that shows that, in my submission, not only are the duties highly limited and circumscribed, but also the consequences of any breach of duty are highly limited, so that, except in case of actual fraud, gross negligence, or willful default, there's no liability, and indeed there's an indemnity which extends all the way from the fund to the individual defendants as employees of an associate.
But I mean, on the judge's findings, there was actual fraud, gross negligence, or willful default.
There was.
So I'm not sure where this fits in. It would be very surprising to find those things excluded, and it seems that they're not.
But the reason why I'm drawing it to your attention is because not dealing with the findings of breach, but simply dealing with the prior question of whether fiduciary duties are owed. It's important to look at the contractual structure and understand how any such, if any fiduciary duties are owed at all, particularly by the individual defendants. I would say that could only happen if consistent with the contractual structure, and what we see here are very extensive limitations of liability and indeed an indemnity, such that this really goes to the point about the individual defendants not owing direct duties to the fund. Such would be very surprising for them to owe direct duties, given this extensive contractual chain where duties owed by any intermediaries are so circumscribed, and indeed, in respect of anything less than actual fraud, gross negligence, or willful default, the individual defendants could subsequently claim an indemnity. So that's where it fits in. That's where
Right. Okay, thank you.
And the last point in this agreement is clause 13, waiver of fiduciary duties. I will perhaps come back to this rather than taking you through it now. But it is the answer to the question, well, wouldn't they just have said so? In my submission, in the heading at least, it's fairly clear that they did say so. And we will discuss the precise wording of this in a moment. Perhaps I'll just invite you to read it rather than my reading it out, and we'll come back to it. If you've had an opportunity to read that, I would now like to move on to the Investment Advisory Agreement, which is at page 23, tab 2 of the bundle you're in.
Sorry, can you just tell us where is the clause about headings?
I'm sorry, the clause 13,
Yes.
waiver of fiduciary duties.
Yes.
And the issue is whether that clause does in fact waive fiduciary duties.
Yes.
There is an issue between the parties, dealt with in skeleton arguments by reference to quite a lot of authority, as to the extent to which headings can be taken into account in light of, on page 8 of the, I'm sorry, I should have drawn your attention to this. On page
Yes, that's
8
what
of
I was asking.
It's clause, it's in fact the second B, but it's clause 1B on page 8, right at the bottom. The headings clauses are for ease of reference only and shall not affect the interpretation or construction of this.
Thank you very much.
So moving on to the Investment Advisory Agreement, which is at tab 2 of the same S bundle. This is made between the investment manager, so FIML, and FCM London. And you'll see that in the recitals on page 25, recite clause 316 of the Investment Management Agreement, and the appointment is made under that. Under recital C, the investment manager wishes to appoint the investment advisor to provide advice. And under E, the investment manager has agreed to pay the fees and expenses of the investment advisor. In the definition section, advisory fee towards the bottom means the fee to be paid by the investment manager to the investment advisor in accordance with clause 4.7. You turn to page 27. You'll see 5 entries down. It's the same definition of gross negligence as we saw. Very similar, I think. As we saw before, referring to reckless disregard of the consequences of breach. Paragraph 2.1, page 28. The investment manager as alternative investment fund manager, FM of the fund, hereby appoints the investment advisor on a non-exclusive basis as its investment advisor in relation to the fund, with effect from the effective date. The point here is simply that, as the judge found, it's repeatedly found, it's FCM London is appointed as the investment advisor and not the individual defendants, not FCM London's employees. And the duties and obligations under clause 3 are set out 3.1 at the bottom of page 28, and they carry on over the page. I should draw your attention to 2 points which my learned friend relies upon. One is at subparagraph F, where it says that the investment advisor shall be responsible for reviewing and evaluating the proposed loan or investment acquisition strategies of the fund when required to do so by the investment manager or the fund. The fact that, I think my learned friend, I'll let him make his own submissions, I think the point is that he says where the fund can make a direct request to the investment manager, to the investment advisor, then it might suggest a direct link between the investment advisor and the fund rather than there being a link only through the investment manager. And I think a similar point is made in respect of subparagraph J. The investment advisor shall prepare material for inclusion in the annual financial investor reports and the quarterly reports of the fund whenever the fund shall properly require such material. I'm not sure that actually means that the fund requests it, merely that it requires it and perhaps the investment manager requests it. But anyway, I'll draw your attention to those 2 points. 3.3, as we saw with the investment management agreement, the investment advisor shall not hold itself out either expressly or ostensibly as acting as the agent of the investment manager or the fund. Paragraph 3.11, over the page on page 30, towards the bottom, it says, it is intended that the investment advisory services of the investment advisor pursuant hereto will be provided by Ben Churchill, Oumar Diallo and Zaki Mohammed as employees of the investment advisor. I think the respondent says, well, the individual defendants are named in this document, which shows that there's some direct reliance on them. But of course, this only says that it's intended that they will provide the services. And moreover, they provide the services as employees of the investment advisor. And of course, the fund is not actually party to this agreement. This is between FIML and FCM London. Over the page to page 31, clause 4.1, the investment manager shall pay to the investment advisor on a loan-by-loan or investment-by-investment basis the advisory fee in accordance with clause 4.7 below and the terms set out in the memorandum, and shall reimburse the expenses of the investment advisor as set out in clause 4.8 below. And then the advisory fee under 4.7 says, the advisory fee shall be paid out of the management fee received by the investment manager pursuant to the investment management agreement. So it is directly stated to come out of the investment manager's own fee from the fund, in such amounts and at such times as the parties may from time to time agree. So it seems to be left very open as to what the entitlement actually was. If you turn the page, it looks remarkably like an agreement to agree, but if you turn the page to 4.9c, there is perhaps a saving provision saying, in the event of any dispute between the parties as to the calculation or amount of any compensation or remuneration payable to the investment advisor, such dispute may be referred on the application in writing by the investment manager or the investment advisor and copied to the other party to the auditors, who shall act as experts, not as arbitrators. In circumstances where Mutaz controls FIML, and Mutaz is one of only 2 directors of FCM London, it must be questioned whether there was in reality any way for FCM London to refer a dispute to arbitrators if some fee hadn't been agreed.
Well, expressly not arbitrators, but
Sorry,
experts.
Sorry, the auditors.
Yes, who act as experts, not as arbitrators. Yeah. Yes.
What would they be experts as to? A reasonable investment advisory fee? I mean, is there an implied, some sort of, if it's not just a framework agreement, which is to be referred to on a case-by-case basis where there is actually an agreement, what is the implication that there would be a reasonable advisory fee paid, as to which the auditors might be able to behave as experts?
I think that must be the case. I mean, it's repeatedly set out that they're entitled to a fee and they're expecting to be paid a fee, and that's certainly the understanding of individual defendants. But yes, it would have to be that there was some sort of reasonable fee payable. If this was. The point I'm making here is that whereas FIML has a clear contractual right to any surplus above the 5% paid to the shareholders and so on, as we've seen, here it's very much left open. So effectively it's left in the hands of Mutaz to agree a fee with FCM London, but which is really a vehicle for sharing fees. So really it's a question of Mutaz agreeing a fee with the individual defendants, which he usually did with Mr. Diallo, as to what they would actually be paid.
I'm afraid I've forgotten what it was that the the offering memo said about fees, because I mean, clause 4.1 does take one back to that expressly, saying the entitlement is the advisory fee in accordance with clause 4.7 below and the terms set out in the memorandum. And the memorandum is defined as the offering document for the fund.
Well, find it.
Page 81.
It's under page 81, S81.
Yeah.
Simply says investment advisory
Yes.
fees
Shall be met by the manager.
shall be met by the manager.
Takes
Out of
one
management fee will generally be agreed on a
Thank
letter
you. Takes one no further.
basis.
Thank you.
So we then come back to page 32 of this bundle and conflict of interest, clause 5.1.
So just pausing before we do that, everything above 5% goes to FIML.
Yes.
So it may be that the investment does fantastically well, and that's very
Yes.
lucrative for FIML. But it doesn't necessarily follow that all of that trickles down to FCM London. It would depend on what was if there is disagreement, on what is a reasonable fee for the services they've provided.
Yes,
Is that
and
right?
I will come on to address this, but one of the repeated issues the individual defendants had is they considered there was an overarching JV agreement that they would get 50%.
Well, I know that the judge rejected that.
The judge rejected that, but this is certainly their understanding, and indeed, as they set out in the defence, there's a table at paragraph 17 that shows that not on every occasion, but broadly speaking, these have been shared 50-50 as between loosely Mutaz parties and the individual defendants. So what the individual defendants talk about is saying they understood that the fees would be paid to FIML and they should get 50% of it. But what happened in practice is that Mutaz and Hussam regularly sought to dilute them, is the phrase they use. And the way that happened most clearly is by making payments to the placement agent. And so one of the things that the defendants objected to about the claimant's diagram produced at trial is it suggested that there was an automatic payment of 50% each to the placement agent and to FCM London. And you will recall that the placement agent of Floreat Merchant Banking was Mutaz as the director, again, as was Mr. Wilcox. But that was ultimately owned by Floreat Holdings, which was ultimately owned by Mutaz, Hussam and James Wilcox. So if one takes the two parties, a fee is paid to FIML as the investment manager. The individuals say, we understood we're entitled to half of it, but certainly it was negotiated, some kind of discussion every time. The risk is that if that fee gets split and half of it goes to the placement agent, what, you might ask, and half of it comes to FCM London, then in effect, Mutaz and his brother and James Wilcox get 75% of the whole pot, and they only get 25%.
Well, it's slightly more complicated than that, because what comes to FCM London has to be used to pay FCM London's expenses, which would include the salaries of the individual defendants. I don't know what salaries they were being paid, but presumably they were getting something before any question of distribution of profits arises. Is that right?
That is, of course, correct as regards FCM London, although in practice that's not how it was done, not how it was done previously, when, as defendants gave evidence that Mutaz were keen to keep FCM London lean, is the word that's used. And so profits were simply paid, well, they'd previously been paid offshore to Floreat Advisors Limited, the Jersey company. And in this case, they were paid offshore to two Cayman companies. So Floreat, FCM London had expenses, but certainly in terms of how the parties seem to have treated the profit share, is that the profit share was divided up first, with the understanding that the expenses would be dealt with at some later point.
But if the documents just set out a structure under which, on a case-by-case basis, there would be an agreement as to what FCM would be paid, and without the agreement, all you've got is the resolution of dispute clause under 4.9c. Whatever the expectation of the parties, I mean, it is just an expectation, isn't it, that the defendants would have, that they would be able to reach an agreement, failing which they could activate clause 4.9c. And the judge has found there's no joint venture.
He has, absolutely.
So we're just faced with a structure under which there is an expectation but no right, and a clause which says if you don't like what you're offered, you can refer it to the auditors.
If you can control either of the parties well enough to refer it to the auditors.
That's the structure that anybody claiming through FCM has to live with.
That is the structure, and the reason why it's important to understand that there is this very loose structure, should we say, from the individual defendant's point of view, is that when they're negotiating with Mutaz as to a share of the fee, they are negotiating, generally speaking, from a position of weakness. So the reason why, we will of course come on to this, but they will say the reason why they made the agreement with Mutaz, the judge of course found he agreed to the diversion of the termination fee on a fully informed basis. They agreed with that, agreed the payment essentially of what they regarded as their share of the profit at an early stage to prevent Mutaz from simply hanging on, this money being paid to Fimmel and him then hanging on to it and finding reasons to delay or dilute them. So they were keen to get an agreement up front. So this is that's why this is important. I'm showing it to you, not because I'm saying there was a clear, absolute contractual right paying through dividends to FCM to a full 50%. Far from it. I'm saying there had to be a negotiation in effect every time because there were ongoing disputes about the extent of the share that Floreat Merchant Bank might take and various other complaints made about diluting their share. So that's why there was a particular agreement at this time. It wasn't just a question of, there would always have to be some kind of negotiated discussion. It wasn't just a question of sitting back and waiting for the funds to come to them, because if they took no steps to do so, there was a real risk that funds might not come or not a reasonable charity.
And just for my own purposes, the benefit of, quote, keeping FCM London lean, unquotes, would be that if it had no right or entitlement to be paid any monies, FCM London, it wouldn't have to pay tax on that income.
And I presume that seems to be the implication, because they talk about, not Mr. Churchill, but I think Mutaz and Hassam and Mr. Diallo and Mr. Nuseibeh are all domiciled offshore, I understand.
So in other words, if the agreement was that instead of FCM London being paid a fee, the money went offshore to FAL Jersey, I think he said. Or at least
these two
offshore.
payments went to IRL in Cayman and to FCM Cayman. But in previous cases, it had been to FAL in Jersey.
Yeah, and that the benefit of that is only obtained if it's as a result of FCM London not having any entitlement which it could be taxed on, and FAL Jersey having the entitlement and being taxed according to Jersey tax laws. Because if it was just FCM London arranging for something to which it was entitled being paid instead to Jersey, it would still have to be taxed in the hands of FCM London, wouldn't it?
Very hesitant to make submissions about the tax consequences of this. But I think that is, what I can say is that I think the parties, as the judge found, did not operate everything strictly by the book way. So you may well be right that it was structured in this way because it meant that...
Well, I should have paraphrased. My question was really directed at what the parties thought they were doing when they, quote, intended to keep FCM London lean. I mean, whether it... You know, I'm not interested in the exact tax.
Yes, I think it's pretty clear that the intent was to minimise tax. So the idea is that...
I'm so sorry. I just don't think that is open to Mr. Elias with the greatest respect. If he's going to make that submission, we ought to be able to source it from the judgment.
I cannot source it from judgment.
I thought not.
I'm attempting to deal with my lordship's question. I started by saying I'm really not trying to make submissions about tax consequences. What I was going to say is I think the way in which the parties understood it is that they were dealing with, as they saw it, the broad share of the profit, and exactly how that came into their hands in terms of exactly how the structure worked. Certainly, I think Mr. Churchill gives evidence that he didn't really understand how it worked. It was just, they were focused on the share of the profit, they weren't focused on the exact mechanism.
I thought the leanness comment was made in the judgment somewhere, isn't it? Or is that somewhere?
It is somewhere.
I think
I
you're
think
right.
it is somewhere, but there isn't, and forgive me if I've missed this, I don't recall seeing any reference anywhere to the domicile of the three individual defendants. I think you said just now they were all non-domiciled.
I think
Non-UK
it appears
domicile.
in the sorry. So in so it's reference at S287 is I think Mr. Diallo's witness statement, where he says it transpired that Mutaz and Hussam do not want revenue coming into the UK. They would use words to the effect they did not mind keeping FCM in the UK, but wanted to be as lean as possible in terms of the revenue onshore, so that profits would be distributed offshore. We did not mind this because Zaki and I are non-domiciled, so we would also benefit from that setup.
Right, I think what we will do, because we started a bit early so that you could all avoid the crowds, and that makes it quite a long morning, is we'll let you finish on this agreement, and then we'll just take a very short break to allow everyone to stretch their legs.
Thank you, my lord. Have I sufficiently answered your lordship's
For now,
question?
yeah. It may come back in the argument, but let's see.
Yes. Thank you. Then, right, well, let's move on. So we're back to page 32 of Bundle S, where clause 5.1 at the foot of this page, we're talking about conflicts of interest. Clause 5.3 over the page, it says, none of the services to be provided under this agreement, nor any other matter, will give rise to any duties which would prevent or hinder the investment advisor or any associate in transactions with or for the investment manager, dealing with other associates and other customers, and generally affecting transactions as provided above, to which the investment manager consents. Accordingly, similar to wording you'd see in the investment management agreement, clause 5.5 there. 5.5 here, the services of the investment advisor shall not be exclusive to the investment manager, free to render similar services to other persons, so long as its services to the investment manager are not impaired thereby, and to retain for its own use and benefit all fees or other monies payable thereby. The investment advisor shall not be under any duty to disclose to the investment manager any fact or matter which comes to the attention of the investment advisor in the course of the investment advisor rendering similar services to others. So these are more provisions which in general terms we say cut back on the duties that FCM London owes to FIML, the manager. So it doesn't, for example, even have to disclose information that might be relevant to an investment. And clause 5.8, some securities considered for investment by the investment manager may also be appropriate for other clients advised by the investment advisor. If the purchase or sale of securities is consistent with the fund's investment policies and one or more of these other funds or clients advised by the investment advisor or by an affiliate are considered at or about the same time, the investment advisor undertakes that transactions in such securities will be allocated among the several clients in a manner deemed fair and equitable by the investment advisor. These allocations may be advantageous or disadvantageous to the fund. It's another example where a conflict of interest is permitted, and what is put in place is a contractual obligation to allocate opportunities in a fair and equitable manner, even though they may end up being disadvantageous to the fund. Over the page at clause 6.3, it says the investment advisor undertakes that it shall and shall use all its reasonable endeavours to procure that its officers and employees shall serve the interests of the investment manager in good faith, discharge its obligations hereunder with reasonable skill and care, and devote such timely attention to the performance of its duties as shall be required properly to discharge such duties in accordance with the provisions hereof. The investment advisor further undertakes that it will comply and will procure as far as practicable, that the investment manager will comply with any provisions of all applicable statute or regulation that the investment advisor is or reasonably ought to be aware in the normal course of business. I highlight this because the investment advisor, that's FCM London, is here contractually undertaking to use all reasonable endeavours to procure that its officers and employees shall serve the interests of the investment manager in good faith. And we'll come and see how the fiduciary duty is put by the claimant and by the respondent in its case. And I said this seems to be pretty directly contradictory to the way that's put. So where there's a contractual obligation to take reasonable endeavours to procure that your employees shall do something, that seems to be rather contradictory to and cannot sit fairly with a freestanding fiduciary obligation to ensure that your employees comply with their duties in that way. And clause 8.1, there's a limitation of liability clause, again limited to actual fraud, gross negligence, dishonesty or willful default. And 8.3, again there's an indemnity clause. The investment advisor, its associates and their officers and employees, save as a result of actual fraud, gross negligence, dishonesty or willful default. And I will come back to these provisions when talking about whether freestanding fiduciary obligations should be imposed on various aspects of this structure in light of these contractual provisions. I've now finished with this agreement, so that's the suitable moment.
All right, we'll take a break till 10:02.
All right. Yes, yes, very right. also have a more important point in saying how does this nothing find this is a fee.
Council, are we ready? All rise.
Yes.
My Lord, a moment ago there was a question about whether the words keeping it lean were dealt with in the judgment. I referred you to the evidence of Mr. Diallo, and in fact parts of that are reproduced at paragraph 54 of the judgment, where the judge says, I accept the following from Mr. Diallo's evidence in chief. it transpired that Mutaz and Hussam did not want revenue coming into the UK. They would use words to the effect that they did not mind keeping FCM London in the UK, but wanted it to be as lean as possible in terms of revenue onshore, so that profits would be distributed offshore. We agreed on the basis that the offshore entity would mirror what we had in FCM London. And this is when FAL came into the picture. Mutaz said he had an existing Jersey company which could be converted to mirror the ownership of FCM London. Any profits generated would be sent to FAL and split.
Yes, thank you.
Sorry, which paragraph was that?
I'm sorry, 54.
54, thank you.
54. And there's a similar point made at 83, which just sort of confirms that, where the judge says the position is further complicated by the use of FAL to receive sums generated by FCM London's operations, as described above from the evidence of Mr. Diallo, which we've just seen, and in this way by Mr. Nuseibeh. Work that was being done by FCM was, if you like, being remunerated in a different entity. That's how.
So that was which paragraph?
That was at 83. So on page 133.
So the idea is that the last bit of this paragraph 54, the offshore structure created a situation where sums generated by FCM London's operations were never in fact received by FCM London. Okay, so that the suggestion appears to be that FCM would not actually be entitled to receive any fees.
I'm not sure the evidence reproduced here goes
No.
quite so far.
Okay,
but
anyway, all right. Well, anyway, it's somehow...
It seems to be a fee that is due by reference to this fund structure, although it's not paid to formerly the investment advisor, FCM London.
So, FCM London has no entitlement under the management agreement. Sorry, the
Investment
advisory agreement. But in lieu of it pursuing an entitlement, an offshore company which has done nothing gets an entitlement to be paid. And by that route, no tax is declared in the UK, but is presumably declared offshore.
Well,
okay, yeah, well,
again, I shouldn't speculate on tax consequences,
No.
but yes, Mr. Diallo says
Well, that seems to be what's suggested.
it was paid to an entity which mirrored the holdings of FCM London. In other words, it was a 50-50 entity offshore, as between the individual defendants and Mutaz, his brother, and Mr. Wilcox. And that was the case with FAL, where the shareholding was split. And in the case of IRL and the termination payment, it wasn't then sent to another company. It was actually divided into two companies. So,
But it would only work. Could only conceivably work for tax purposes if FCM had no entitlement to be paid anything.
without speculating on the tax consequences, I've shown you the relevant provisions of the agreement, and I would say it seems to be.
I mean, speaking for myself, I just don't think we have anything remotely approaching the material we would need to even express a tentative view on what the tax planning was. All we can, I think, say is that obviously some kind of tax advantage was perceived in structuring matters in this way, rightly or wrongly, goodness only knows.
Well, Mr. Diallo's evidence, which the judge accepted, is that that's how Mutaz and Hussam wanted to structure it. And they said they were happy.
Yes, and if they were non-domiciled and had non-dom status, that normally means you only get taxed on income on a remittance basis, and all considerations of that kind may have entered into the calculations, but that's really guesswork.
You've seen the provision of the investment advisory agreement, which is left vague, is at best, really, as to what might be paid. So we were just to finish this rather overly extended tour of the documents of these contractual agreements. We should look at the placement agent agreement on page 45 of Bundle S, tab 3. The investment management agreement and the investment advisory agreement were both dated the 20th of August 2015. This is dated the 8th of September 2015. That seems to come slightly afterwards. it's made between Floreat Investment Management Limited, FIML, and Floreat Merchant Banking, ultimately owned by Mutaz Hussain and James Wilcox. On page 48, there's the same provision regarding gross negligence at the top of that page. And on page 49, we see the placement agent's duties and obligations. The placement agent shall promote the shares in the fund, distribute and provide to eligible potential investors in the UK such documentation and marketing as the manager has provided, procure that potential investors are sent a copy of the current version of the applicable memorandum, and keep an accurate record of offerees, and so on. So the obligations of the placement agent are, as you'd expect, fairly minimal in terms of organising investors into the fund, but not in terms of the ongoing activities of the fund. On page 50 is where the placement agent has provisions for fees and expenses. In consideration of the services described in this agreement, the placement agent shall be entitled to receive, and the manager shall cause to be paid, an administration fee on an investment-by-investment basis, in such amounts and at such times as the parties may from time to time agree. So it's similar to the provision in the investment advisory agreement, except that there is no express provision here that any such payment is to come out of the management fee payable to FIML by the fund, which we saw in the investment advisory agreement. There seems to be not even the provision for referring disputes to auditors in this contract. That's all I wish to show you on that document. So we have now discussed fees in some detail, but just to reiterate the position, the fund had shareholders who were entitled to a 5% return. FIML was to meet the costs of the fund and was entitled to any profit above that 5% return. FCM London's entitlement to fees, as we've discussed, were left really very unclear. And under the placement agent agreement, it was also similarly unclear as to exactly what the Floreat Merchant Banking might be entitled to. The role of Floreat Merchant Banking was as a placement agent to procure investors into the fund. And because it did so little, this is one of the reasons why the individual defendants considered that when fees were paid to FMB, this was a dilution of matters that should really be due to them. But what we can see from this fee structure is, while there clearly had to be a negotiation if the individual defendants were to benefit from any kind of profit share, there clearly had to be some kind of negotiation because that was envisaged by the agreements. And really it was in the hands of FIML, so Mutaz negotiating as FIML, virtually negotiating with himself as Floreat Merchant Banking as to what fee the placement agent should get, and negotiating with himself and Mr. Diallo as the directors of Floreat FCM London as to what fee FCM London might get. But in practice, as we've seen, it was an agreement about profit share that was then paid to offshore entities, mirroring the FCM London shareholding, so 50-50.
I take the point that Mutaz is, in a lot of this, effectively negotiating with himself. But if we take the structure at face value, the individual defendants seeking to get a good fee for FCM London would be entitled to say that if unreasonably high fees had been paid to the placement agent, that was something which should not reduce their fee, and if they couldn't agree that with FIML, to ask the auditors to rule on it.
That is.
I mean, you may say that's unrealistic given the position of Mutaz, but that's the structure.
That is That is the structure.
Yes, I see.
Although strictly, as I think I mentioned earlier, it would be either FIML or FCM London would have to refer the matter to the auditors. And the fact that FCM London had 2 directors, of whom Mutaz was one, might well mean that in practice it wouldn't even be possible for FCM London to refer it to the auditors. But that's we were firmly opposed.
And Mutaz and the individual defendants thought it was perfectly okay to negotiate a situation where FCM London received nothing for the services that it had performed.
But that seems to be the position in circumstances where FCM, and that's clearly what happened, the evidence is that's what happened, but in circumstances where the shareholders of FCM London were ultimately the same 6 people, 3 individual defendants,
so
Mutaz, Hassan and James Wilcox.
But as I was trying very badly, no doubt, to put it, it's not a situation of them agreeing that FCM London would be entitled to a fee, which at its direction would be paid somewhere else. It's actually an agreement that FCM London would not be entitled to receive anything. But in place of that, a mirror image, as perhaps it's put, in place of it, somebody else offshore in which there were similar shareholdings would be paid a sum of money.
Well, that seems to be what happened. I don't think the judge made findings exactly as to how each of the individual people involved in that transaction perceived that transaction to work.
No, I'm just reading from paragraph 54. Well, sorry, I was just looking at paragraph 54 and 83 of the judgment, which you pointed us to.
In practice, the judge accepted Mr. Diallo's evidence that what happened is that when there was a profit, even though, as he put it, a profit generated by FCM London's operations, so FCM London was the active part of the structure. The fund had non-executive directors. FIML was an investment manager which passed through the kind of active consideration proposal of particular investments. So the active part of the fund, if you like, was FCM London. That was the entity for which all 3 of the individual defendants worked. They're employed by FCM London. And so, in that sense, it was generated by the activity of FCM London, because the funds, FCM London was doing the work which found the investments which came to the fund.
There is no profit share agreement.
There is no profit share agreement.
So, I mean, in many ways, 83 is more accurate. FCM London is doing work, but in fact has no entitlement to be paid for it absent an agreement. There isn't one. And such remuneration as to which it might otherwise be entitled, had there been an agreement, is in fact being paid to a different entity offshore. I mean, that's what I'm reading in paragraph 83.
That seems to be what happened. What is not found, and what is not found, but I suppose what is implied, is that FCM London would not, once this profit share arrangement had happened, FCM London would not then be in a position to demand a separate fee. That's
okay. Anyway,
not a finding.
And we don't know how this was dealt with, do we, in FCM London's accounts or tax calculations submitted to the revenue, corporation tax, anything like that?
None of that is dealt with in the judgment.
Do we know whether the individual defendants actually drew a salary from FCM London?
They did draw a salary from FCM London. It varied in amount. I think it went up to £100,000.
150,000.
It went up to, I think it started at 100 and went up to 150.
Where did that money come from?
I understand that FCM, I think it's Mr. Diallo's evidence, the individual defendant's evidence, is that FCM London incurred expenses and in fact had loans from other parts of the Floreat structure because it was understood that it would eventually, they would eventually have to be paid off, or that would eventually be sorted out. But in terms of the individual transactions, it seems that the profit was simply considered as sharing of profit with the expenses to be dealt with at some later point.
Okay, where do we go next?
So we've talked about fees, and I've mentioned that the individual defendants were concerned about their fees being diluted. And there are just a couple of points in the witness evidence of the defendants I would like to take you to. If you take bundle S1 to start with. And at page 288, which is in the very last tab, tab 25.
Mine goes up to tab 27, I think, but it's 25 you want, isn't it?
I'm sorry, yes, tab 25, page 288. This is the individual defendant's evidence about their concerns about dilution, as we've called it. So paragraph 37, so the last sentence of paragraph 36, last two sentences, he says, FIML was simply a pass-through vehicle for FCM to generate fees via the fund. The risk was that Mutaz, having full control, could undermine the profit share any time funds were channeled through FIML. Mutaz and Hassam seized that opportunity early on by requesting a distribution fee for FMB. Hassam said he had no economic exposure to FCM and therefore was not part of the profit share agreement and had to be compensated elsewhere. This was despite his 45% ownership in FHL, which in turn was a 50% shareholding of FCM, and Mutaz's references to paying Hassam and James their share of FCM's profits. When Hassam said elsewhere, he meant via FMB, so we were forced to agree that GFI would pay a fee to FMB. No terms were ever formalised, which meant that Mutaz and Hassam decided on a deal-by-deal basis what FMB would claim. The initial deals, it consisted of paying half the excess running yield, so this is referred to various other prior transactions. In the case of Doric NAS, we were paying FMB 1%. The deal was paying 7%, the investors took 5%, leaving 2% excess running. This was unfair and unjustified given Hassam was already remunerated as a partner in FCM. And so to appease us, they reiterated the agreement in his words that fees would never be shared, so upfront or exit fees in FCM transactions would be for FCM alone. He also talks about, as he carries on the next paragraph, the attempts to dilute our share of the profits were relentless and came to dominate the relationship and create mistrust. At the end of December 2016, when FAN 1 closed, I sent a WhatsApp message to Mark Dardis, who worked for Sam within FBM, saying, issue with Floreat as the partners, will find a way to say it's not our core business and divert the revenues. It was a constant pressure point. And perhaps Mr. Churchill says something very similar, page 272 of this bundle. Paragraph 56, at the bottom of that page, Mr. Churchill said, as I've said, the fund was not a good vehicle for our ambition to an FCM because it effectively ruled out genuine outside investment. About 5 lines up, also Hassam, through FMB, demanded distribution fees on FCM transactions. Despite the profit share being nominally 50-50, the imposition of FMB fees and other little tricks, such as intracompany loans above market rates, worked to reduce our effective share to more like 30 to 40%. We knew Mutaz and Hassam were doing this. They must have known we were aware of it. We knew it was not something to object to, we just had to accept it as the cost of doing business with them. This generated a lot of tension.
The judge has held there's no profit share.
He held there's no profit share agreement. This is the individual defendants. They are explaining why they felt this was unfair, why their concern was about being diluted as they saw it from what they thought was an overarching 50-50 agreement. In fact, I mean, their own evidence is that in practice they didn't actually get 50-50, but that's what they say they understood they had gone to business to do. So they were, but these parts of evidence is not to say that there was such an agreement, of course not, but it is to say that they were very much concerned that they would be diluted, and that once money was in Mutaz's hands, if I can put it that way, he would find every reason to reduce their share. So I think I explained earlier, so with FMB and FCM London, if in fact FIML received a fee from the fund and simply split it between two of those entities, then either split between the two or paid in accordance with FCM London's shareholding, then it means the individual defendants would receive effectively 35%, and Mutaz, Bassam, and Wilcox would receive 75%.
Just for my reference, the paragraphs in paragraph 54 of the judgment to Mr. Diallo's evidence in chief, what's the reference to the witness statement we've just been looking at?
It's S287 is where that comes. It's paragraphs 33 and 34.
Thank you.
Moving on briefly to the role of the individual defendants in the structure. The contractual framework which we've been looking at clearly provides that they were to be involved in their capacity as employees of FCM London. It's suggested by the respondent that we're reformulating our case by calling them mere employees, but in fact the judge consistently held throughout the judgment at various points at which he was invited to hold that matters had been delegated to the individual defendants, and he persistently held that they had in fact been delegated to FCM London, albeit that the individual defendants were FCM London's employees. And so, for example, you can look at, if you look at the judgment at several examples of this, but let's look at 136, which is at page 143. You will see that at 137, paragraph 135, the third factual finding, 6.8, sought by the fund at trial, was that the individual defendants ought to have known about the NAV asset assessment requirement and break fee clause because they were required to undertake FCM London's role as investment advisor to the fund. And what the judge says at 136 is, I'm able to make those findings, except that I'm not able to accept that Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh were required to undertake FCM London's role as investment advisor to the fund. FCM London had the role of investment advisor and was required to undertake that role. Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh were its employees. And there are a number of other examples. Let's look at one more.
I think before you do, I think this is the first time we've been taken to a part of the judgment where the judge is dealing with these requested factual findings. Can you tell us, please, how that document came into being? Was it something which the judge asked for, or was it something which was simply put forward by the respondents?
It was certainly put forward by the respondents as part of their written closing submissions at trial. I'm afraid I'm not able to help your lordships as to whether it was something that was raised, specifically requested by the judge, but certainly the defendants did not put forward any similar set of factual findings afterwards. So as far as I'm aware, and my learned friend can answer this, as far as I'm aware, this was volunteered, offered by the claimant, but was not requested by the judge specifically.
Right. Okay, well, if that's mistaken, then Mr. Jones will tell us in due course, but we'll proceed on that basis.
I was about to show your lordships one other example of the judge emphasising that it was FCM London that was the investment advisor,
yes,
and the individual defendants were its employees. This is at page 191, paragraph 390 of the judgment. Where the judge holds, to the extent that Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh controlled information or managed the operation of the facility, they did so as employees of FCM London. It was on FIML and FCM London that the fund relied, including to manage its exposure to loss. So again, it's the judge rejecting the idea that the individual defendants were, rejecting the idea that the redemption of the facility generally had been delegated to them personally rather than to FCM London. Just coming back to, as it were, the key events, which I'm sure you have seen, but just to reiterate, I don't wish to rehearse all the matters set out in the judgment, but the key event is on the 19th of June 2017, when Mr. Mutaz Ataibi and Mr. Diallo, on behalf of the individual defendants, agreed that the termination fee would not be paid to the fund, but, we say by way of shortcut, should be treated as if paid to FIML, and then onwards to companies representing the Floreat Group's interests, that was FCM Cayman, and the individual defendants' interests, that's the fourth appellant IR Relations, and should be paid directly to those entities. On the 23rd of June 2017, Reading Football Club paid the 2.2 million termination fee to Burgess Salmon, and on the 26th of June 2017, IRL and FCM Cayman each received payments of approximately 1.1 million.
Burgess Salmon are solicitors to the fund, is that
solicitors to the fund, yes. Transfers from IRL's account, that's the Cayman entity, were then made to bank accounts in the names of each of the first defendant, the third defendant, and jointly in the names of the second defendant and his wife, which is why she was made party to the proceedings, no doubt. In the first instance case, as your lordships will have seen from the judgment, although the judge found against the appellant in relation to the diverted sum, the judge very substantially rejected large parts of the claimant's overall case. So at trial, the respondent's case was that Mutaz was kept in the dark. So the respondent sought to recover prepayment fees in the sum of approximately $825,000 that it said that the individual defendant should have demanded and would have received from Reading Football Club. The judge rejected this claim. He found that Mutaz had given what he termed the instructions to FCM London to achieve early repayment and in that effort to ignore recovery of fees to which the fund might be entitled. That's paragraph 124 of the judgment. He was quite satisfied that the instructions were given by Mutaz, that's at page 141, and he considered the idea that Reading would have paid additional fees on a prepayment that had been requested by the fund was commercially unreal. I don't think we need to go into this in much detail, but you may recall that the fund persuaded Reading to make an early repayment from accounts which had been blocked as part of the fund's security since they were blocked. Reading was happy to repay them, but the judge said it was commercially unreal, the idea that it would have agreed to this request by the fund and then paid further fees. The respondent also sought at trial to recover what it called a missing termination fee payment in the sum of just over $800,000. This was the difference between the fund's contractual rights under the financing agreement and the exit fee negotiated by FCM London of 2.2 million. The judge also rejected that claim. He found that the instructions given by Mutaz were to redeem the loan.
Sorry, isn't that the same claim?
It's a different claim. There was one claim relating to prepayment fees. There was approximately 2 million was paid in December 2016 and a further 2 million in, I think, March 2017. The missing termination fee payment was a different sum. The actual termination fee paid was 2.2 million. That's what ended up being split.
Yes.
The claimant said at trial that the respondents were in breach of duty in various ways by not insisting on the fund's full contractual.
Yes, no, I got that. The 800,000 missing fee.
Yes, so that's a different sum from the prepayment fees, which came in relation to the payments in, looking to my right, December 2016 and March 2017. And the judge said that that negotiation was effectively covered by the instructions to obtain repayment and never mind fees, and also considered that the sum was a commercial fee reached in good faith given possible difficulties with enforcement. Importantly, the respondent alleged that Mutaz had been misled by what it termed were bonus fee misrepresentations. And this was because he acknowledged that he had agreed that the funds could be paid offshore to the Cayman entities, but he sought to say that he had been misled into believing that these were somehow purely extra contractual bonus sums, hence the terminology he sought to use, to which the fund had no entitlement. And he said he had agreed that had been misled by these bonus fee misrepresentations. But the judge rejected the idea that any such representations had been made. You can see that at 273 and 279 to 80 judgment. So the judge overall found that Mutaz essentially knew what was going on. He knew the diverted sum was contractually due to the fund, but nonetheless agreed to the contractual shortcut, as we put it. At 342 of the judgment, perhaps we just look at that because it's important to see it. That's on page 183 of Full Bundle. Where he says, 342, I do find that Mr. Mutaz al-Taibi knew that the Reading FC payment was a termination fee due to the fund. I also find that he gave informed consent to its diversion, and then goes on to say it was not open to him to agree that. But he says he gave informed consent to it. So at trial, in order to exonerate Mutaz, it was said that he only agreed this on the basis of misrepresentations, and the judge firmly rejected that. And indeed, on various occasions at trial, the judge squarely rejected Mutaz's evidence. There are various examples, but there's one at paragraph 122 of the judgment, where the judge says, in his evidence, Mr. Mutaz denied concern about Reading FC's ability to repay the financing, but I do not consider that denial frankly truthful. There are other examples, perhaps another one in relation to the bonus fee misrepresentations. That's paragraph 274. The judge said, I do not accept the addition of the word bonus by Mr. Mutaz al-Taibi, and what he attributed to Mr. Nuseibeh in the third highlighted exchange was true and accurate. In other words, Mutaz had said it had been misrepresented to him that this was a bonus fee, and the judge said the word bonus wasn't said. And as we've seen, so contrary to Mutaz's evidence and the claimant's case at trial, the fund found that Mutaz knew that the Reading FC payment was a termination fee due to the fund, and he gave informed consent to his diversion. The elements in which...
So sorry, it was therefore Mutaz, that's to say the claimants, who were saying that this was a bonus extra contractual payment,
Yes.
rather than the individual defendants who were saying it was the termination fee, or it was a profit share.
The individual
what was your
defendants
side saying?
freely admitted that it was a sum contractually due to the fund. That wasn't disputed. And Mutaz...
And that's Mr. Diallo's evidence, which the judge quotes. Perhaps
yes.
among other places, perhaps.
So, the claimants didn't say that it was in fact a bonus fee. What they said was, Mr. Mutaz had been lied to by the individual defendants, the bonus fee misrepresentations. And that was the basis on which he agreed that it could be paid offshore to Cayman. It wasn't the claimant's case that it was in fact
I see.
a bonus fee, but the judge rejected the idea that he had lied to in that respect.
So, at the risk of stating the obvious, you say the judge found that Mutaz knew and consented to the diversion of the termination fee to the offshore entities.
Yes.
In a way that he was contrary to his authority from the fund.
Yes, that's what the judge
And a company which he owns and controls is now pursuing a claim against the individual defendants for
Yes.
the self-same diversion.
Yes. My learned friend may say, perhaps, I should point out in fairness, that technically FIMLA is pursuing the fund's claims on the basis of an assignment. But yes, the result appears to be that FIMLA is pursuing the claim, the sole shareholder in FIMLA.
Which it has presumably taken an assignment of in return for some Do we know the details of the assignment?
The assignment's not in the appeal bundle. I'm fairly sure it was in the bundle at trial. It is taken, I will no doubt oversimplify it because it's not in front of me, but my understanding is that it was assigned to FIML, and the key terms were that FIML would pay any, as it were, profit from the litigation back to the fund once it had taken out any expenses. And also, I think the fund gave some kind of indemnity to FIML in respect of presumably these related claims against FIML.
But anyway, so far as this litigation is concerned, no point was taken below, and none is taken in this court, that because of Mutaz's or FIML's involvement in the diversion of the money, they're not entitled to pursue the fund's claim as assignees.
Well, no, it certainly wasn't put in that formal way, but it was said that this is essentially abusive litigation. It was revenge litigation, maybe with the views of bankrupting the individual defendants.
Yes.
We will come on to...
But it's not a ground of appeal that this is
It's not a ground of
litigation. No.
Dealing with some more of the contemporaneous documents in the bundle, there are a number of Bloomberg chats in the bundle, S tabs 11, 12 and 14, that my learned friend will no doubt take you to. And this, of course, formed the subject of some considerable investigation at trial as to what they meant and as to what the individual defendants were doing. The respondent, no doubt, points towards these as evidence of the individual defendants trying to mislead Mutaz. My submission in the context of this appeal is that it's important to bear in mind these chats don't concern attempts to mislead the fund. Individual defendants say that they were concerned to limit the information given to Mutaz to manage him in a context where he would often interfere in the running of the fund in an unprofessional and unhelpful way. So there's an example of this is given by Mr. Nuseibeh in his witness statement, and that's at S333, so that's bundle 2, the supplementary bundle. Mr. Nuseibeh says at paragraph, I'm sorry.
333?
Supplementary bundle 333.
I think that's bundle 1. Supplementary.
I'm sorry, I have the page in a different place.
I think my Lord's bundles have been divided in terms of tabs differently. I am in bundle 2.
Oh, gosh.
Tabs 26 and 27
Yes.
are in my bundle 2, but for some reason my Lord seems to have them at the end of bundle 1.
Lucky me. All right. Okay, I think I'm in now. Which paragraph?
It's page 333, paragraph 100.
Thank you.
This is just Mr. Nuseibeh's evidence saying, I relied on Oumar for advice on how to deal with Mutaz. I can see now that some of our chats make it look as though I was trying to keep things secret, especially the Bloomberg chat on the 14th of June. As I think is clear from that chat as a whole, however, the concern was really as to when and how to broach issues and avoid triggering some unhelpful overreaction or unprofessional response. By this time, there was a lot of mutual suspicion and defensiveness. So, in terms of some of the things in the Bloomberg chats, I would simply say that these attempts to manage Mutaz, keep information from him, the judge found ultimately that Mutaz gave his informed consent to the diversion. So in my submission, I merely say that one has to be very careful in looking at this and not taking it any further than it warrants in terms of what the individual defendants thought about the fund or about their entitlements to these monies generally. The appellant's case is that the contractual shortcut was a mechanism by which the substance of the parties' arrangements could be given effect. The evidence given at trial by the individual defendants was that each believed that Mutaz had authority to act for the fund in authorising the shortcut. And the individual defendants each believed that, as at the date of payment of the termination fee by RFC, the fund had ample funds to meet the 5% preference dividend such that the termination fee would inevitably have been paid to FIML. And I'll obviously come back to make good those propositions. So in those circumstances, we say, those are the circumstances in which the individual defendants negotiated with Mutads, as we discussed. It was envisaged they would do under the contractual documentations, and certainly as in practice seems to have happened, and reached an agreement as to what would happen with the profits. They did what had previously been agreed between them, which was to pay the money offshore to keep FCM London lean. And we say the shortcut was no doubt ill-advised, but it was not dishonest, as the individual defendants believed they would not cause any prejudice or loss to the fund. And in this context, I do want to show you what was referred to at trial, I think, as the follow the money disclosure. Because you will have seen that in 2019, FCM Cayman, which had received the other half of the termination fee, repaid that sum to the fund with interest. Now, the judge, of course, found that Mutads knew all along that that sum was due to the fund. But the defendants suggested at trial that that was done as an artifice in order to strengthen the idea that money had simply been paid to FCM Cayman by mistake. And so when the mistake, unquote, was discovered, they paid it back to the fund with some interest. Now, when that happened, the same sum of money that was received, 1.1 million plus interest, just over $1.2 million, was then pretty much immediately paid by the fund to FIML as management fee, which is exactly what the defendants had been saying all along would have happened if it had been paid to the fund at the time when it was earned. So if I invite you to look at a judgment at paragraph 349, and here the judge notes that 348 and 349, that on the 6th of May 2021, the fund was ordered to produce documents evidencing the contemporaneous justification of an accounting process undergone in relation to the fund's payment to FIML in June 2019. The fund had actively resisted providing this disclosure. Now, in fact, if you turn back to 347, you will see that this came about in response to, sorry, it's paragraph 347 of the judgment, page 184. This came about in response to an RFI that had been requested, in which the fund had refused to answer, but were ordered to do so. You can see that in 347, Mr. Adrian Beltrami, QC, ordered the fund to comply with that request for further information. Now, the claimant's RFI response, this is now in core bundle 2 at C358,
Sorry, give the reference again.
so 358 of core bundle 2. And you'll see at point 106, well, the request is, as regards the nearly 1.1 million received by FCM Cayman in June 27, allegedly repaid to the fund in March 2019, please state the claimant's case as to how the money allegedly repaid to the fund, including interest, was dealt with by the fund. Answer, it's denied the matter is of any relevance. And at 106, without prejudice to that contention, the fund paid this exact sum, you'll notice, down to the cent, 1099968.28, plus interest to FIML on about 12th of June 2019, being the monies the fund had received from FCM Cayman in respect to the diverted termination fee payment in order to pay for FIML's legal fees in these proceedings. FIML had ceased to be investment manager of the fund on the 1st of January 2019. So that was the response. The fund then refused to give disclosure on the issue, but were again ordered to do so, as the judge notes at paragraph 348. This disclosure was given on the 19th of May 2021, the trial beginning on the 21st of June 2021. And the idea that this was some kind of loan or contribution to costs was maintained in the claimant's skeleton argument for trial. I can perhaps give you the reference. It's paragraph 65, paragraph 14.8 at S343, and paragraph 65 at S359. So that was maintained in their trial skeleton. But in fact, the documents disclosed by the funds, they're eventually forced to produce, showed that the termination fee repaid to FCM Cayman was not repaid to assist with legal fees, but because the fund administrator determined that it was contractually due to FIMON. So if you would take what I hope is the first bundle of Bundle S.
So these documents were disclosed during the trial?
No, about a month before. We say that the fund, first of all, refused to answer an RFI on the subject and was obliged to do so by order, then refused to disclose the relevant documents and was obliged to do so by order, and as a result, they only emerged a month before trial.
Right.
And the key documents disclosed were in Bundle S, tab 20, page 214. S, tab 20, page 214. This document, single page, memo from the administrator, who you can see at the bottom is Maples Fund Services Cayman Limited, the fund administrator, the board of directors, dated 30th of May 2019. And it recites that the note issuance facility deed granted to Reading, it recites the settlement received by the fund in 23rd of June 2017. Termination fee was agreed at $2.2 million. On the 26th of June 2017, an amount of $1.099 so on dollars, the principal fee representing the termination fee, was transferred to FASL rather than to GFI. It has been determined that the fund is entitled to, FASL, I should say, we can see from two paragraphs down, is Floreat Aviation Services Limited, formerly Floreat Capital Markets Limited. So that's the Cayman, FCM Cayman we've been talking about. It's been determined that the fund is entitled to receive the principal fee and interest thereon at a rate of 5%. We refer to the letter dated 16th of April, whereby the fund has requested payment. The amount of 1.2 million odd was received into the bank account of GFI on the 17th of April. In accordance with the confidential information memorandum of GFI, the manager, in lieu of any fee, shall be entitled to retain any excess in the fund's net income over the amounts required to fund the preference dividend of each series, the excess income. And then this final paragraph. Had the RFC termination fee been received by GFI in June 2017, it would have been recorded as income to the separate account of Series 1 and would have constituted part of the excess income for the period which would be paid to the manager. As such, the amount of 1.2 so on received by GFI will be recorded as amount due and payable to the manager, Floreat Investment Management Limited. So this disclosure showed that what the individual defendants have been saying in their witness statements, their case was, if this fee had been paid to the fund, it simply would have been paid straight out to FIML. This is what the administrators of the fund are confirming. It said it would have been constituted excess income for the period. It would have been recorded as income and paid to the manager.
But what about paragraph 351 of the judgment? The judge doesn't accept that.
paragraph 351, what the judge says is, viewed as at June 2017, I cannot accept that this is what would have happened. So he rejects it. He doesn't reject it because anyone has cast doubt on the document. This is disclosure by fund, after all. He rejects it because he says, I note the defendants did not believe it at the time. It was precisely because of their material concern that this would or might not happen that they took the steps they did to route half the sum of the termination payment to themselves directly. But in my submission, there are at least two mistakes going on in that analysis. And the first one is to say that the defendants were concerned about paying the money to the fund. Well, that isn't right. The concern was about it ending up in criminal, whereupon Mutaz, as sole executive director, effectively, you've seen the contracts, would have far too much power to deal with it as he liked. So the concern, as we will see, wasn't that the fund would not pay it out. The concern was that Mutaz that it would go to FIML and then FIML would not pay it out. And the second way in which, in my submission, that finding doesn't stand up is it confuses the difference between what FIML was contractually entitled to and what they feared might happen if somebody had taken the money en route, if we put it that way. It would be, defendants believed that FIML was fully entitled to this money and reached the agreement with Mutaz on that basis. If the judge says, well, they were concerned that it might not reach them in practice, that's not, he doesn't say because the fund would have misappropriated it or the fund wasn't obliged to pay it up to FIML, and of course he doesn't make that finding. What he says is the defendants in practice were concerned that it might not make its way to FIML and down the chain, and for that reason, he seems to make a finding that they didn't believe that they didn't believe that FIML was entitled to it. There's a difference between believing what a proper entitlement is and being concerned that somebody might mislay it along the way. The key point is what the defendant will of course come back to this, but the key point is what the individual defendants believed. And if they believed, as we say they did, and as the evidence supports, that the money would inevitably be paid to FIML in the sense that it was inevitably due to FIML and absent some major fraud along the way, then it would reach FIML. They believed it was contractually due. The fact that they were concerned that if the money was paid to FIML, Mutaz might then take part of it or take more of it than they thought was fair, doesn't mean that, it doesn't follow that this undermines their belief that FIML was contractually due to it. The things that meant whether FIML were contractually due to it is to do with their understanding of whether this termination fee would be profit and would be paid to the fund. And so the reason why the follow the money disclosure was so important is because it shows the administrator says if this payment had been paid at the time, during the period, it would have been paid out to the manager. So we say what
But the judge's reasoning, if you look at the fact, I referred you to 351, but if you take that together with 352, he's saying not just that if FIML had got it, they might not have passed it on. He simply doesn't have confidence that the fund would have paid it to FIML in 2017.
Well, he says...
He just doesn't regard the 2019 follow the money documents, as you call them, as a reliable indication of what would have happened in 2017. I mean, you might be wrong about that, but that's what he seems to be saying, isn't it?
He is saying that, but what I say to that is that no one had challenged the authenticity of the documents. The fund had produced them, and it was the document we've just looked at, was the document produced by Maples as the fund administrator, who was saying, this is what would have happened. The fund produced the document very much against its will. It accorded with exactly what the defendant said would happen. And what the judge seems to have done is to say, well, because I've not got full underlying disclosure and facts of the fund's position, I'm going somehow to disbelieve this document as it were, in favour of the fund, which has been forced to produce it. And the situation is made worse because what the fund then says is, well, in order to be satisfied with this, I would need a full explanation and examination of the underlying material from the fund. And of course, it's very much in the fund's hands, and indeed in the fund's interests, to produce that material at trial, to say, notwithstanding this document, actually, that can't be right, because we can look at the position of the fund here, or whatever it might be, and say, and here are the documents that show that that's not right. But what the judge has done here is he has found in favour of the fund on a point, essentially by reason that they did not produce the material which was in their hands and in their interests to produce.
What was the date of the assignment and course of action?
I'm afraid I would have to check that for you. It might be in the chronology. So, in relation to this paragraph 352, I'd say if the judge is simply going to reject a document which has been forced to be disclosed against interest, there ought to be some reasoning why he's saying, I just don't accept what the administrator says. It might be different if the defendants have produced some document that supported their position, but this is the fund administrator, this is Maple's fiduciary, this is Claimant third party. And in my submission, the judge is then being unrealistic in saying, well, I could only make a finding that it would have been paid out by conducting a full explanation of the fund's financial position, which information I've not got, even though it would be in the fund's interest to produce it. And also, crucially, when we get onto the question of dishonesty, the point is not just would the fund have paid this money to Finnell, but did the defendants subjectively believe that it would? And reasonableness is not a requirement of that belief, but nonetheless, the more reasonable a belief is, the more that is likely to help persuade the court about what the subjective belief was.
Just as a general comment, it is an incredibly steep hill, isn't it, for you to persuade us that the judge's findings on the subjective state of mind of people who gave evidence and were cross-examined at length before him are wrong.
Well, I will, of course, go through that.
I mean, you know, there's masses of authority about the circumstances in which findings of fact can be overturned in an appellate court. And I thought those warnings, well known as they are, must apply, I would have thought, with particular relevance to findings about the subjective state of mind of a witness who has given evidence.
Well, paragraph 351, the point I'm making there is that what the judge finds is he doesn't find that they didn't believe that it was properly payable to Finnell. He just says he finds that they were, so in other words, he doesn't make a finding about what they properly believed Finnell's rights were. He simply makes a finding, which is not disputed by the defendants, that they were concerned that Mutaz would misappropriate the money. And the defendants, of course, say that was likely to happen when it reached Finnell and Mutaz was in a position to deal with it. So I'm not saying that the judge's finding is wrong in the terms in which it's put, because he was saying they were concerned that Mutaz might misappropriate. I am saying it's not the appropriate finding to make in this context, where one's looking at dishonesty in relation to the sum, because the question is really, did they believe that by paying it or treating it as paid direct to Finnell and then negotiating with Mutaz, did they believe that this was going to deprive the funders of money? Did they believe that the fund was required, Finnell was entitled for this money to be paid as they treated it? It's a different question to say, were they concerned that somebody along the way might misappropriate it, contrary to all parties' proper rights?
At some point, you will doubtless, or are you going to deal with the state of mind of Mr. Mutaz, of Mutaz, in relation to this transaction, and particularly the diversion?
Yes, I will come on to how Mutaz saw things is part of my submissions on the dishonesty point.
What the judge says elsewhere, 437 and 460, for example, is that the defendant's belief was that the fund would not have paid the money out straight away, but would have treated it as subject to the net asset value assessment requirement before it could be paid out. And that, I suppose, might indicate that it would not have been paid out in 2017, or not necessarily, although even if, with the benefit of hindsight, in 2019, there was no reason why it couldn't be. Is that right?
Which part of the judgment are you?
437, for example,
437, sorry.
where he quotes factual finding 12.1 and then makes it paragraph 438.
He makes that finding. He doesn't give any reasoning to support his finding. And moreover, the finding that the fund would have treated it as income, even if that finding were to stand, subject to the net asset value requirement, it still doesn't, that is simply a precondition for it being paid out. It still doesn't prevent the judge from making a finding as to what they actually believed, which was this money was inevitably going to Fimmel, even if there might have been some delay. I mean, inevitably, they would have received the money by reason of it being paid straight to their bank account slightly earlier than they would have done, one imagines, if it had gone through the fund and then through to Fimmel.
Was there any cross-examination along the lines of what is said in the finding at paragraph 437?
I will certainly take you to some cross-examination about the defendant's belief as to how the funds would have been dealt with. And you may recall I said in opening that if one looks at this finding here, for example, which has no reason to support it, and in light of the extensive evidence as to what the defendants said, one would expect the judge, if he's going to find against all that evidence, to at least provide some cogent reasons for rejecting it, rather than simply stating it. But in my submission, even that finding doesn't alter the underlying belief of the defendants that Fimmel would have ended up with this money. Fimmel was ultimately entitled to it. While we're looking at the disclosure, I should just finish this point. We've looked at the document from Maple's fiduciary. On the next page, page 215, you'll see that this is a written resolution of the directors of the company in relation to this sum. At 2.1b, they assert that the amount of 1.099 so on was transferred in error to Floreat Aviation Services Limited. The news has, of course, knew that wasn't right. At 2.1g, this is the written resolution of the directors holding that the reimbursed amount is an excess amount and therefore was and is payable to Fimmel. And accordingly, it was then paid out to Fimmel, as we've seen shortly afterwards.
So you're going to have to go back over those. Yes, I can see it.
I'm sorry.
Yeah, no, I can see it. Sorry.
2.1b and g.
Yeah.
And then the next page is the fund's financial statements for the year ended.
Just out of interest, how did the directors of the fund? There's no indication as to how they knew that.
I'm sorry, as to how they knew
that it was an error, apparently.
I don't know where that comes from.
I mean, an error sounds like an error could be taken to be an honest mistake.
That is, I would say, the impression it's designed to give. But I don't think anything turns on it particularly. The tab 22, page 219, these are the fund's financial statements for the year ended 31st of December 2019. And just for completeness, you can see that on page 224, it shows other income in 2019 as 1.2 million odd. And there's a note at 11.1, which is on page 251. And the note at 11.1 simply records that the manager, in lieu of any other fees, is entitled to retain certain monies, which means that the 1.2 million formed part of the reimbursable excess amount available for distribution to the investment manager. That's in the penultimate paragraph, last 2 lines. So the judge said, and seemed to find, they're not really with explanation, that couldn't rely on these documents, but he did have the letter from the fund's administrators, the resolution of the board of directors, the fund's account for the relevant year, showing that it was received by the fund and then paid to the investment manager, FIML, in accordance with the investment management agreement as we've seen. Is that a convenient moment?
Yes, certainly.
Moving on.
All right. Well, we'll adjourn till 2 o'clock. As we started slightly early, we'll finish at 4 o'clock today.
All rise.